Hello and welcome to today's webcast entitled Social Media at Work, Managing Risks and Opportunities. My name is Jeff and I will be your web event specialist today. During the presentation, we will have a question and answer session. You can ask questions at any time during today's presentation. Please click on the green Q&A icon in the lower left-hand corner of your screen, type your question into the open area, and click the send button to submit. If you would like to view the presentation in full screen view, you can click on the full screen button in the lower right-hand corner of your screen. You can press the escape key on your keyboard to return to your original view. Finally, for optimal viewing and participation, please disable all pop-up blockers. Should you need technical assistance, as a best practice, we suggest you first refresh your browser by pressing F5 on your keyboard. If that does not resolve the issue, please click on the menu option in the upper right-hand corner of your screen and select the support button for online troubleshooting. It is now my pleasure to turn today's webcast over to Dr. Peter Hurst, Executive Director, MIT Sloan Executive Education.
Thank you, Jeff. This is Peter Hurst from MIT in Cambridge, Massachusetts. Hello to everyone and welcome to our Innovation at Work webinar series. I'm sitting here today with John Akula, Senior Lecturer in Law at the MIT Sloan School of Management. And John will today be talking to us about social media at work, managing risks and opportunities. John, as I mentioned, is a senior lecturer at MIT Sloan who teaches law to various students here at MIT. In particular, John also teaches a two-day law course aimed at executives called Essential Law for Executives, the MIT Advantage, in our executive education program. Before John joined MIT, he had a distinguished career as a lawyer in his own right. And I won't go into the details of that, but you have that on a slide in front of you at the moment. So with that brief introduction, it's my pleasure to hand over to John Akula.
Peter, thank you very much for that kind introduction, and thanks to all of you who've taken time from your busy schedules to join us in this webinar. We're going to be talking about social media. And by social media, I mean platforms like Facebook and LinkedIn, which are basically designed to facilitate users communicating with one another. We're going to be talking about the law. We're going to be focusing on how an appreciation of legal risks and opportunities can make you a better manager. And we're going to be talking about social media at work. And by at work, I mean both social media activities that are part of an official company's business, but also social media activity by employees and managers, which they may think of as personal, but which the law may view as having some relevance to, some legal relevance to the company. Before we get started, a quick disclaimer. This is an educational program. I'm not giving you legal advice, and I'm not your lawyer. What are we going to try to accomplish? Well, I'm hoping that in the hour we have together, I can give you some appreciation for some of the ways that law is developing in this area and shaping the opportunities and risks that you face. And with that appreciation, I'm pretty sure you will come out a better manager in some ways that we'll address quite specifically as we go along. And also a more intelligent consumer of professional legal advice when you need it. Now the next slide, slide number 5, is really nothing but a table of contents for the entire deck, and you may want to consult it later on if you're going back to these materials, but I don't think we need to focus on it now. The law, at least the way I look at it, is a very practical discipline. And there's no better way to stay practical than to think in terms of real management problems. So that's where I'd like to start. On your screen right now is a problem. And let me read it to you. Imagine you're a senior manager at BigCo. One of the employees tells you that a half dozen other employees in your unit are spending a lot of time complaining to each other about you on Facebook, including the way you assign overtime and how raises and promotions are handed out, and they're sharing details about individual pay. Some comments are nasty, and a few are a bit obscene. There are also comments that deal with other supervisors and your boss. And access to these postings is not restricted to employees of the company. Some outsiders can see them. Your company has a social media policy, which every employee has agreed to in writing. The policy prohibits demeaning comments about the company or other employees and the sharing of confidential information with anyone inside or outside the company except on a need-to-know basis. Now, I'm going to ask you what you think you ought to do and give you some choices. Now, please keep in mind that there are no right or wrong answers to any of the questions I'm going to pose. And that, in fact, a manager would always want to have a whole lot more information than I'm going to be able to provide before he or she made a decision. But I think it's useful to get a sense of where our initial inclinations lie. So now you're going to see on your screen some choices. Here they are. 1, are you inclined to ignore the matter because the employee's conduct is legally protected? Option 2, are you inclined to ignore the matter because making an issue of it would probably just draw more attention to it? Option 3, do you want to take appropriate measures to see if the company's social media policy is reasonably enforced? Or perhaps to you, none of the above options sounds right. I'm going to give you about 10 seconds to vote, which I know isn't much time, but I think it's probably all we need. Okay. And now you will see on your screens the result of the poll. Most of you are inclined to take appropriate measures to see that the company's social media policy is reasonably enforced. By the way, there are good reasons for adopting any of these positions, but what I think might be helpful is that if I put on my lawyer's hat and talk a little bit about some of the legal issues that are relevant here and why a lawyer might take a somewhat different perspective than a typical manager. We have a system in this country of at-will employment, which means that an employer has a great deal of discretion and can, in fact, even dismiss an employee for almost any reason at almost any time, unless the employee is protected by a fairly precise list of exceptions to that rule. And the issue here is, when does an employee's expressions, speech on and off the job, leave him or her open to an employer's sanctions? When is that speech protected? Well, we do have a very strong commitment in this country to freedom of speech. Does that matter in this case? Probably not. Freedom of speech is a constraint upon government, not a constraint upon private employers, and the courts have held over and over again that employers can dismiss employees for comments both off and on the job that they find objectionable. We have a very robust body of anti-discrimination law, which says that employers can't take action against certain protected classes based on certain characteristics. Might sometimes be an issue, but probably not in this case. A couple of states have adopted what are sometimes called lifestyle discrimination laws, which limit the right of employers to take action based on legal out-of-work activities. If we were in one of those states, that might be an issue, but that's only a minority view. We have many laws that protect what's called whistleblowing from any kind of retaliation by an employer. But typically, whistleblowing protection attaches only when the issue has a clear public interest. And being unhappy with your boss probably doesn't count. But we also have a statute in this country, the National Labor Relations Act, which mostly relates to unions and collective organizing, but has one very important provision that applies to employees everywhere, and that provision protects so-called concerted action from any retaliation by an employer. And the heart of concerted action is employees getting together and discussing their wages and working conditions and what they are unhappy about. This law didn't get much attention until recently, but in the last couple of years, the National Labor Relations Board has made it an enforcement priority. And in fact, many of the leading cases involve Facebook dialogues, just like the one I discussed. And so a lawyer is very likely to take the view that you need to think long and hard about whether or not this conduct is legally protected before you take any action against it.
Thank you, John. That's a very interesting example. I've noticed we have about 300 people on this webinar now, and some of them are asking questions, and I'd encourage others to keep asking questions through the platform, and we'll try to interject a few. One idea that's come up here is, your example mentioned the fact that the comments were perhaps obscene, some of them, and also they were being read by people outside the company. Seems a little tough on a company to expect them to have to accept that. Does that sound right to you?
Well, Peter, your comment is very much on point. There are a lot of folks out there who feel the National Labor Relations Board has been stretching pretty far in defining what kinds of activity are entitled to protection. As to reaching out to people outside the company, their view is that sometimes that's clearly appropriate. You're entitled to get advice and support from those outside the workplace. As for the obscenity issue, which has come up in several cases, their view has been that when people are really unhappy with their jobs, they don't have to always be polite about it. But what's probably going to happen in this case, what typically happens in the American legal system, is that a regulatory agency stakes out a new issue and defines its powers as it thinks are appropriate. As the years go by, some of their determinations are appealed to the courts. And when the courts take a look at the same issue, they often take a slightly more restrictive view of what the agency should be doing. So we may see some backpedaling in this area. But as of now, the kind of fact pattern I gave you is very much a problem. Tell you what, let's change our focus. When managers are worrying about legal problems, they generally have in mind both keeping themselves out of trouble and keeping their company and their colleagues out of trouble. And usually all of those interests are aligned. It's the same agenda. But there are some circumstances where those interests are not aligned. And when that's true, a manager has a much more complicated and much more risky set of problems. And for senior managers, one circumstance where that's most likely to arise is when you decide to change jobs. When a senior manager leaves a company, quite often to go to work for a competitor, the company feels quite threatened. And let's talk about how that plays out, especially in the social media context. In terms of the overarching legal framework, we have four basic sets of principles that come into play. On the one hand, our legal system is very strongly committed to the view that people ought to be allowed to change jobs and pursue their careers. And that's probably the strongest principle of all. On the other hand, companies are allowed to protect their trade secrets and confidential information. Every employee owes to his or her employer a duty of loyalty. You don't violate that duty of loyalty when you're planning to make a move, but there are some things you can't do so long as you're still collecting a check, like soliciting your current employer's clients in the hopes of taking them with you. And there are a great many contracts that employers have employees sign, non-competition agreements, non-solicitation agreements, confidentiality agreements, and the like, that also typically specify certain parameters the employee has to respect. This is a fundamentally conflicted body of principles. And how does it play out in practice? Well, the way it plays out in practice is that given the fact that there's really a very strong bias towards letting people pursue their careers, managers can in fact be quite aggressive when they're changing jobs in terms of pursuing their own interests, so long as they are careful about not engaging in any activity that unambiguously violates any of the rules. How does social media affect this mix? Well, quite dramatically. For example, let's look at the days before we had social media and digital communications. People work their way through these situations in face-to-face conversations and phone calls. Face-to-face conversations don't leave any written records. There's no evidence as to what was indisputably said. There's lots of room for winks and nods. And a lot of that went on. Nowadays, people are using electronic media, including social media. And that leaves written records that can be retrieved. And it is now routine when a senior manager leaves a company and the company is troubled by the departure, that the company brings in experts to do a full forensic review of any electronic communications which that company has the right to access. Often that right, by the way, is quite broad. If your company gave you a smartphone and a notebook and a laptop computer when you took your job, you also probably signed an agreement giving them the right to record, monitor, and review any communications you made on those devices. And what the company does is search for a smoking gun. Maybe there's a LinkedIn exchange between you and one of your contacts at the new company in which you gave them some assurances about the kind of information and skills you can bring with you. And those assurances are, in fact, legally problematic given the right of your current employer to protect his trade secrets and confidential information. Maybe there's a blog posting which, read carefully, looks pretty clearly like an attempt to solicit clients and other employees before you've left. Now the leverage is very different. Your old employer has some indisputable evidence that you crossed a line, something they can show to a judge, something they can use to embarrass you and your new employer in court. This is happening a lot, and it's making a big difference. And you as a manager need to be a whole lot more careful about how you navigate these sort of tricky legal waters. Another social media issue. Social media accounts themselves have become, in some situations, fairly valuable assets. Imagine you have a LinkedIn account. Your company considers your expertise an important part of its marketing pitch, and so they've strongly encouraged you to spiffy up your LinkedIn account as much as possible and given you a good deal of support. Maybe they've also encouraged you to build as extensive a network as you can with key personnel at current clients and at prospective clients. And maybe they've given you some leads as to who you should contact. Maybe you've even tucked away in your LinkedIn account information you've collected from prospective clients along the way. Now you're leaving to another job, a competitor, and you want to take it with you. You think it's your personal account. Your company may say, wait a second. You developed that with company resources on company time. It incorporates confidential information. We don't think you should have the right to take it with you and use it. Same kinds of issues are arising around blogs and Twitter followings. These cases are just coming to the courts, and very few of them have been resolved yet. What's the takeaway? You have to think this through in advance, if at all possible. You have to try to avoid this problem by not commingling what's clearly company confidential information with any of these accounts you might personally have. In the long run, my guess is most of these disputes are going to be resolved in favor of the company because the company is going to be drafting policies that give them very clear rights in this area, and employees and managers are going to sign them. But this is a very, very risky area, made more so, I think, by social media than it was before.
John, maybe if I pause there, we have some interesting questions coming in about this segment, and one set has to do with we're talking about employee privacy and employer monitoring, but much of the material is perhaps very personal, and we have some questions coming in. I think with two thrusts. One is, well, if this is personal, what's it got to do with my employer? Then there's also some questions. Some people are dealing with issues of what about people's private behavior and that they see in their personal social media and how that affects the employer. And also, people seem to understand if they're using their work computer that there are certain things that they're going to apply. But what about things that people might be doing in the privacy of their own home on their own personal computer equipment and social media? What is the right of the employer to get involved in that?
Well, that's kind of our next topic, but those are very good questions. Fundamentally, the law does respect privacy to some extent, but most employees and managers have a sense of what is personal that is quite a bit broader than the law's sense of what is private. Private is things you tell your spouse behind closed doors. Private is the consultations you have with your lawyer and your doctor. Private is the stuff you keep in locked cabinets. Personal is not the same as private. And if you're in a courtroom and you put something up on a social media bulletin board, and you're trying to convince a judge that he or she shouldn't be allowed to see it, even though it relates to a matter in a case before the court, you're going to have a hard time doing that. And in fact, the next topic I wanted to talk about was precisely this one, this tension between privacy and monitoring. Let's take a look at slide 9 to put this in a framework. You're quite right. The fundamental problem here are widely disparate expectations as to what the typical manager-employee thinks should be his or her own business and what a typical employer thinks they ought to be allowed to keep track of. We don't have much in the way of very strongly protected privacy rights in this country. What we do have is the law taking what you might call a balancing approach. Typically, the law asks, does the employee in this case have a reasonable expectation of privacy? And if so, what interests is the employer asserting that would justify an intrusion into that private space? When you apply that balancing test to the world of social media, it's quite striking that you typically come up with a very, very narrowly protected reasonable expectation of privacy for a couple of reasons. First of all, lots of employees have signed these agreements which basically give the employer the right to monitor any activity related to the office or even outside the office that uses office-provided equipment. And then there's the second factor we've already talked about. Once you've posted something on an electronic bulletin board, it doesn't sound private anymore. Even if you do end up with a reasonable expectation of privacy that the law recognizes, you're going to have to counterbalance it against the interest the employer is asserting in monitoring. Employers have a couple of arguments that they make that are given a great deal of weight. One is their just general interest in workplace productivity and decorum. If I've hired you to work for me for 8 hours a day, if you're spending 5 hours a day on Facebook, I want to know about that. There are other situations where the employee and the employer have squared off in some kind of conflict, as when the manager's changing jobs. When that happens, pretty much anything the employee has done is fair game, whether it's done from the home, from the office, on a private account, on a company account. Probably the most general and most interesting interest that employers assert is that if an employee's activity can get the company into trouble, even though the employee thinks it's personal, the company has the right to know what's going on. And we're going to talk about that at some length. But the general balance is very, very heavily in favor of the employer in these cases. But just one cautionary note. Every once in a while, an employer goes too far. For example, we have out there a whole bunch of statutes, which we can loosely call anti-hacking statutes, which are designed to protect electronic communications and stored communications from unauthorized access. It has sometimes happened that an employer has used heavy-handed tactics to get access to some sorts of communication. For example, there might be a bunch of employees on Facebook. The employer might want to know what's going on, might call one employee into his or her office and press them very hard to surrender a password. If that happens, a court could find that that consent was coerced, that there was no real consent, and that what the employer engaged in was unauthorized access to those accounts, and that some of those nasty anti-hacking statutes are implicated. Bottom line is, don't be too much of a bully boy about this. That kind of thing can come back and bite you. Let's move on to the next slide. I want to give you another problem, and it's the one that's up on your screen right now. You're the president of BigCo. BigCo is located in a state which prohibits discrimination based on sexual orientation. Willie Wordsmith is one of your senior managers. Your state has scheduled a referendum on legalizing gay marriage. Willie is strongly opposed. He believes that society has been too tolerant of gay lifestyles, but he's lately become more careful about not broadcasting his views around the office. However, Willie has become a regular contributor to a popular blog on the marriage issue and developed a substantial following. Willie has told you that he blogs only on his own time. 3 employees who were supervised by Willie have come by to see you. 2 of them live openly gay lifestyles with their partners. They tell you they've always felt uncomfortable around Willie because, as one of them says, he thinks we should be illegal. Now that he's developing his blog following and getting a big name for himself with lots of airtime, their discomfort is growing. They ask you, as the president of the company, to do something to address this problem. And after speaking with them, you call your lawyer for advice. Now here again, this is a very complicated problem with no right or wrong answer, but I'd really like you to give me some idea of what your initial inclinations are as to what you think the lawyer might say. And so let me put up for you a poll. Here are the choices I'd like you to consider. Perhaps the lawyer will say, Willie's personal blog posts are not the company's business, and so it's not appropriate for you to intervene. Maybe the lawyer will say, Willie's conduct appears to be unlawful harassment of the complaining employees. You need to make sure it stops. Maybe he'll say, the legality of Willie's conduct is unclear. You should not take any action given that uncertainty. Maybe the lawyer will say, the legality of Willie's conduct is unclear, but if you want to, you can insist that he stop and ultimately fire him if he does not. Or maybe, choice 5, none of the above options sounds right. Once again, let me give you 10 seconds to cast your ballot. Okay, and here are our results. Very much a split decision, which I think is appropriate because there are strong arguments to be made for each of these positions. Here again, though, let me emphasize some aspects of this problem that might typically seem to be more important to a lawyer than to a manager. The lawyer is going to be very worried about litigation. Litigation has tremendous costs to a company, tangible and intangible, whether or not the company wins or loses. One aspect of that cost is embarrassment. We have in this country a system of pretrial discovery, which gives those who sue a company very broad powers to go through all the company's records. What is that search going to turn up? Has Willie really been as careful as he said he has been about never blogging from the office? Are we going to find emails that he's written to like-minded colleagues at the office saying some things he wishes he hadn't said? Are his emails going to be the opening door into a network of communications involving multiple managers in the company who perhaps have said embarrassing things? Very few companies come out of the discovery process without being embarrassed. That's going to be very much on your lawyer's mind. Lawyers are also going to be thinking very critically about this distinction between on-the-job and off-the-job behavior. Chances are Willie has had some comments to make in the office, and even if all his blogging was on his own time, can't an employee reasonably argue that if he was making more intemperate comments outside the office that were public knowledge, that gives added weight and import to perhaps the more careful comments he made within the office? So that turns out in practice to be a very blurry line. Lawyers are going to also think very carefully about exactly who here has protected legal interests and who doesn't. Now, the employees do have a protected legal interest if this rises to the level of harassment. By the way, my guess is on these facts, a case for harassment would be pretty thin. But Willie has no protected interest on the facts I've given you. He's an employee at will. And if the lawyers look upon him as what they sometimes call a lawsuit waiting to happen, with all the costs that could mean for the company, the lawyers may be a lot more inclined to thinking seriously about option 4 than would a lot of managers. And that would be, I think, a typical lawyer's take on this kind of problem. Let's move on. What I'd like to do now is think a little bit more systematically about the issue that this problem raised, which is, when can an employee's personal social media activity get a company into trouble? First, some broad legal backdrop. We have in this country some doctrines that very broadly attribute to companies responsibility for the activities of their employees whenever they are acting within the scope of their employment very broadly defined. If an employee commits a crime, the company is deemed to have committed the crime. Even if the employee's actions were contrary to company policy, even if an hour before he did it, supervisor sat him down and said, "Don't you dare do that here." If I am run over by a FedEx truck because a driver ran a red light, not just the driver ran me down, the law says FedEx ran me down, even if FedEx was as careful as it could have possibly been in the way it selected and trained and supervised that driver. By the way, the rules in the United States in terms of this kind of attribution are somewhat more harsh than the rules in many other places. How does this play out in the social media space? Well, people don't get run over by trucks in social media, but intellectual property rights get violated, trademarks get tarnished, reputations get defamed, and as to all those kinds of legal wrongs, if there's an argument to be made that the employee was acting within the scope of their employment, the company will be liable. There are also some kinds of legal problems that are aggravated greatly by the social media context. There are a lot of legal problems that can be created just by the leaking of information. For example, in the public company space, we have all kinds of very strict rules about appropriate pathways for companies to take information to the market. If a company has trade secrets, the fact that those trade secrets are being leaked in any manner can very much compromise any legally protected interest the company has. There are a bunch of regulations that get a company into trouble if someone speaking on behalf of the company made a representation. Example, the pharmaceutical industry, company gets into a lot of trouble if anyone makes any claims related to therapeutic benefits that the FDA has not approved. To manage this risk, companies are often very careful about who they authorize to speak for the company. Problem is, the law doesn't treat that designation as the end of the matter. In fact, what the law often says is that someone in the eyes of the law has spoken for the company if a reasonable listener would deem that person to have been speaking for the company. If you have high-level executives or managers with expertise in particular issues, and they are, say, blogging about the company or those particular issues for which they have responsibility, can you really be confident that no reasonable listener would think they were speaking on behalf of the company, whether they in fact have authority or not? This makes that whole territory extremely risky.
John, some interesting questions that were coming in while you were talking through that section. There's a whole set that maybe we'll get to later, but I'll just flag them up about to what extent these are quite U.S.-centric questions, and many companies and their employers and their customers are globally distributed these days. But maybe we'll come on to that in a little while. But just to acknowledge to those folks that are asking those questions, we'll get to it. When we're talking about ourselves, our employees, and managers engaging in social media conversations out there, conversations are of course two-sided. And we have some people asking about what about our customers and clients or competitors talking about us and doing things in social media that affect us? What are our obligations? What do we have to be concerned about in interacting out in social media in response to those kinds of conversations that are happening?
Well, that's a really complicated issue. Take the pharmaceutical company example. You might be able to come up with some rules that you think would protect you as to what your own employees can say about therapeutic benefits that are off-label. But other people aren't bound by those rules. And if your employees are having a conversation online with folks who want to talk about it, that's going to be a very, very hard line to draw. And in fact, some companies who are in very sensitive regulatory areas have looked at this risk, have decided that there's no way to manage it, that it's just too large. And they are trying to distance themselves from social media as much as they can, taking measures like disabling any links to social media sites on all their company equipment. But of course, most companies don't go that route. And what you have to do otherwise is you have to think pretty carefully about what the major risks are to which you're exposed. You have to come up with good policies, and then you have to manage accordingly.
So what about those disclaimers that we often see that say something like, these are my own personal opinions, not those of my employer? Do those help?
Might help. I'm not sure you can really count on most of your employees following any instructions you give them in that regard when they're chatting in social media. Let me step back from talking about specific issues and offer a couple of thoughts about how managers more generally effectively address these kinds of concerns. I think one of the key insights that savvy managers have is that they really play, in the eyes of the law, many different roles. And those different roles have different kinds of expectations. I mean, one set of expectations, perhaps the simplest, is don't break the law, stay out of trouble. That's usually pretty simple, especially in situations where your interests and the company's interests align. As we've already mentioned, when that's not the case, it gets a lot more complicated. It also can get a lot more complicated when, say, a major client or customer is pushing you pretty hard, and you have to master the art of what I call push back. But those lines are usually pretty clear. There's another set of responsibilities, which we might broadly call supervisory. One of the very significant trends in American law these last 10 or 20 years has been a very, very substantially growing emphasis on the responsibilities of supervisors. And often this is very specifically addressed in regulatory schemes. It's your job to make sure on your watch that the people you manage are educated, trained, and monitored. And if there's a problem on your watch that could have been avoided had you taken those precautions, that problem is likely to be legally yours, as well as the problem of the folks who actually broke the law. Another role has to do with responding to concrete problems or crises as they arise. Because no matter how good your systems are, no matter how good your people are, sooner or later, something goes wrong. And here the law is really especially harsh because the general thrust of the law is that once you know about a problem, you're going to be held to an extraordinarily high standard as to how you manage it. But as a practical matter, you're often at a real disadvantage. You don't know all the facts yet. These situations are breaking very fast. Not everybody is being honest with you. These crises occur infrequently enough that you probably don't have a lot of experience as to how to deal with them. And responses are often fumbled. And a fumbled response often leads to more substantial liability for both the company and the manager involved than the initial offense. That's a real big problem. By the way, this is somewhere lawyers can really help. Good lawyers have had a lot of experience with this kind of stuff. And if you're talking to a lawyer, at least you're not sitting in your office doing nothing, kind of like that proverbial deer in the headlights of an onrushing car. When you have a problem like this, if you don't know what to do, get on the phone and call a lawyer. And there's a fourth role, which has to do with developing broad policies, what we might call a governance role. And the other management issues are very different. The kinds of problems you run into when you're developing policies are that, well, typically there are some people in the company whose job it is to develop policies, who are often very responsive to legal concerns, to outside constituencies, who may be watching the company carefully. And they are often tempted to develop policies that are a bit too aspirational, that sound real good, but that the company can't really live with. If you've done that, you've set yourself up for a big problem. Even if the policies that are developed are reasonable, you still have some major management concerns typically. There are going to be some people in the company on the operations side, on the finance side, on the marketing side, who are going to be subject to a lot of pressures to cut corners, who may actually not think the policy is really all that important a part of the company's business. In fact, may be profoundly cynical in some cases, look at them as so much window dressing. And without a lot of really effective management follow-through, you can have lapses, even from very reasonable policies. And legally, this gets to be a really big problem. I mean, for example, take the whole issue of consumer privacy in the social media context, which is a very hot regulatory issue. We don't have much law in this country that protects consumers, but the Federal Trade Commission is very active in this area. And what they have mostly done is gone after companies who have enacted privacy policies and then not followed them. What they say to those companies is, we can't tell you what kind of privacy policies you have to have, but we can tell you that you can't be deceptive. And if you have a policy and then you don't do what you said, that's a deceptive business practice. Very easy case for the regulators to win. They don't have to work very hard hanging you when you've quite conveniently gone off and hung yourself. And if you look at the nasty enforcement actions that have taken place in the consumer privacy social media space, most of them relate to companies that just didn't follow their own policies.
So thank you, John. You've mentioned a few times the question of practices and laws that apply in the U.S. and throughout the presentation we've been receiving these questions that relate to the transnational and global aspects here, and I guess they fall into a few categories. One is my employee base is actually globally distributed. This is all very well, but how can I possibly have a global policy that will address these questions? And the second would be, how can people doing things in other parts of the world get me into trouble in the U.S.? Because it sounds like the U.S. is the place that you don't want to be in trouble for these things.
Peter, those are excellent questions. And in fact, I had left for the end of this presentation a list of what I called other issues that are up on your screen right now. Issues that I wasn't going to have time to discuss in length, but I would have felt really remiss if I didn't mention it all. And let's skip right to the last one, which is the transnational dimension. We live in a world where most law is the law of sovereign states. And for some business purposes, that's not a big problem, because the legal systems of at least the highly developed nations look very much alike. Unfortunately, for the kinds of legal issues we've been talking about, there has not been that pattern of convergence. Employment law is radically different from one country to another. We are extreme in our at-will employment doctrine. That's not the way most of the rest of the world thinks. We are extreme in our body of anti-discrimination law. Most of the world has very little of that. We are extreme in our protection of whistleblowers. Most of the rest of the world thinks whistleblowing is a despicable business. We are different with respect to privacy. We protect it much less than most other countries. And so the moral is that your instincts as a manager don't travel very well across national boundaries in this area. And that means you have a much more complicated problem than you would have in many other kinds of management situations. By the way, you probably do have to worry a bit more about the United States than most other jurisdictions, because we have what I think can only fairly be called a nastier legal system. Our regulators more routinely impose really severe sanctions for noncompliance. We have a litigation system that very strongly encourages private litigation for very large amounts of damages. And so if you're somewhere else, but you have a substantial business presence in the United States is probably the jurisdiction you have to worry about the most. Let me real quickly touch on these other issues, okay, running from the top. Terms of use. As you know, when you want to access a corporation's web page, you typically have to click on terms of use to which you agree. And those terms of use are often very one-sided, giving the company a lot of protection and giving you as the user almost none. That's been a great comfort to corporate America. In the social media space, the shoe is on the other foot. When you want to set up your corporate Facebook page, you click on Facebook's terms of use. And those terms of use are as one-sided to protect Facebook as the corporate terms of use were to protect your company on your company's web page. Not much you can do about it, except you can give the matter some thought. Read the terms of use carefully and see if there's ways you can mitigate the risk. So, for example, if the terms of use give the social media platform provider some very generous license rights to any IP you post on the page, be careful what you put up. Second topic, drafting a company's social media policy. We've kind of talked about that already. Key management problem is realistic policies and then follow through. A lot of the risks are industry specific. You have to do a careful assessment of what the risks are for you and what your appetite for risk is. Third topic, internal company social media sites. Many companies have these, and they're used for internal conversations of different kinds. Perhaps you want to be sure that employees in different parts of the world who are dealing with similar problems can communicate with one another and develop best practices. One problem that comes up quite frequently is people start having fun on these sites. Next thing you know, they're swapping recipes, talking about who's going to win this weekend's sporting events, having contests about who can come up with the funniest jokes. That very easily gets out of hand. And sooner or later, some people show some very bad judgment about what they put up on those sites. I think many companies have decided that they wished that at the outset they had established some very clear parameters about what kind of conversations were appropriate, because it's much easier to stop people from going down that path than to rein them back in once they already have. Last topic, social media and the hiring process. It's become quite common for people who are going to interview a job prospect to Google them, see what they can find on the internet and social media sites as well. Because of our anti-discrimination laws in this country, most companies are very careful about the information they ask applicants in the formal interview process, because there's a lot of things you don't want to know. If you have found out, for example, that a woman is pregnant, you're going to have a hard time convincing a judge or jury that you didn't take that into account in the hiring decision, even though the law is very clear that you're not supposed to. And now we have a situation where managers are routinely doing an end run around those policies and procedures. Lawyers will tell you there's some risk there.
That's an interesting point. Probably it could be a subject of a webinar in its own right. I don't think that this webinar is either personal or private, so I'm not going to say anything about that, but surely there are a few of us listening who might have been tempted to do exactly that, and I think that's a really good lesson and indication for all of us of the kind of trouble we could get ourselves or our companies into if we're not sensitive to these kind of issues that are out there. So, John, this has been fascinating, and we've been getting actually quite a few questions of people looking for help pointing to other resources that they may be able to access to help them to understand some of these issues. Of course, I would be remiss not to mention that John does have some upcoming sessions of his 2-day executive education course at MIT, Essential Law for Executives, coming up on December 13th to 14th. And sorry, I'm just got another question coming in. So I'm just checking on the questions there. So John has a session coming up on December 13th, 14th. His course runs 3 times a year. John has also been putting together some resources for us that will be, look out for an email from us in the next few days, where we'll make available to you some resources that John has put together. So we have a couple more minutes before the end of the webinar, and if I may, I'm going to ask John a very difficult question just to end up, and that is, Clearly, you've touched on a number of issues that people are quite concerned about, and we've had a lot of questions coming in directly and not so directly related to these topics. But in the general area of this question of social media at work, what's one thing that we should all try to do when we put down the phone, turn off our computer, and get back to work, maybe this afternoon or tomorrow morning? Is there some action we can take that would put us and our companies in a better place than we are right now as it relates to the social media question?
Really good question, Peter. One problem with lawyers is that if all you did was listen to all the things they worry about, you wouldn't have time to do anything else. In fact, you probably wouldn't even get up and go to work in the morning. You just put the pillow back over your head and go to sleep. What good managers have is a very highly modulated response to legal risks. They develop a sense as to what they really have to worry about and what they don't. I think probably the most useful thing the managers out there could do, if they have 10 or 15 minutes, take out a pad, take out a pencil, make a list of the things that you would worry about if you had all the time in the world, which you don't, and then put a star next to the one or two or three things that you really do have to worry about. Because given your risk profile and given your appetite for risk, you really don't want to see yourself going off the rails on that one. Maybe there's nothing you put a star next to, in which case you're in pretty good shape. But if there are some items that you really think need some attention and that you would be giving some attention to, but for the press of business, well, make up that short list and start thinking about them. That, I think, is probably the most useful thing you can do. By the way, in connection with additional resources, on that last slide with my contact information, the last line is my official faculty webpage here at Sloan. If you go to that webpage, there's a link at the bottom to my unofficial faculty webpage, which is where I keep all the interesting stuff. On the unofficial webpage, there's a navigation bar on the left, and one tab is Social Media at Work. Click on that, and you'll get a listing of some materials I've pulled together. There are a couple of websites and blogs which have collected company social media policies along with a lot of commentary as to what sorts of issues you should be concerned about. There's a very good newsletter that traces legal developments in the social media space in terms that are not directed at lawyers but at managers. There's some links to some key Federal Trade Commission recent documents on social media issues, and some links to some National Labor Relations Board issues. I'll probably be adding to that additional resources page over time, and so you can take a look at it now and maybe take another look at it a month or two from now again.
John Akula, thank you very much. Thank you all for participating, and with that, I bid you all farewell and be safe, and we look forward to seeing you at the next webinar, which we'll be sending a message about shortly.
And Peter, let me add my thanks too. Very glad that you had the time to tune in.